Breaking news. British High Court kicks against IPOB leader Nnamdi Kanu's illegal rendition to Nigeria. Kanu had approached the court to challenge the United Kingdom's government for not defending him, despite being a citizen, against the Nigerian government. Hey guys, welcome back to Prospect Channel TV. Thank you for coming out here. If you are just joining us, please kindly subscribe and don't forget to give us a thumbs up. Thank you. The British High Court has made an unconventional ruling in a significant human rights case centered on Nnamdi Kanu, a British national and the leader of the indigenous people of Biafra, IPOB. Kanu had approached the court to challenge the United Kingdom's government for not defending him, despite being a citizen, against the Nigerian government. His legal team, led by John Harford, head of public law and human rights in Blindsman LLP, had said that in June 2021, Kanu was adopted from the airport in Nairobi, Kenya, by Nigerian Security Service, and was detained and tortured for around 10 days in Kenya. He was then flown blindfolded on a private plane to Nigeria. In a statement on Thursday, Aloy Ejimakor, the special counsel to Kanu and IPOB, said, though the UK High Court frowned at the rendition to Nigeria, it however ruled that the Foreign Secretary did not have to reach the same conclusion. He said the court also highlighted extracts from the opinion of the UN Working Group on Arbitrary Detention and the Nigerian court, which unanimously found that Kanu was subject to extraordinary rendition and which called for his release. The Working Group on Arbitrary Detention is under the United Nations Commission on Human Rights. The group comprises scholars and experts who specialize in human rights issues and related laws. In its report on July 20, 2022, the UN group described the Kanu's repatriation from Kenya in June 2021 as illegal, unlawful, or constitutional extradition. It also called for the immediate release of the IPOB leader and compensation by the Nigeria and the Kenya government for the way he was treated. In the document, the body also indicted both Nigeria and Kenya for Kanu's abduction and rendition. Despite the call by the UN Working Group, the Nigerian government has, however, failed to release the IPOB leader. Ejimakor said, with Mr. Justice Swift, noted the founders of the UN Working Group on Arbitrary Detention and the two separate rulings from Nigeria's High Court and Court of Appeal that Mr. Kanu had been extraordinarily renditioned to Nigeria following his interception in Kenya by Nigerian security forces, and observed himself that Mr. Kanu had been subject to rendition. He went on to hold that the Foreign Secretary was illegally entitled to make no decision on whether this is the case or not. Blindsman's LLP, the legal team, acting for Mr. Kanu's family, described the ruling as extremely difficult to reconcile with long-standing legal precedent and the principle underpinning it. Mr. Kanu's case was heard over 4 months ago on the 15th November 2022. In today's judgment, Mr. Justice Swift noted that evidence of serious wrongs having been committed against Mr. Kanu, including that in 2017, the Nigerian state had attempted to kill Mr. Kanu, for which a Nigerian High Court awarded compensation and an order for apology. That the Nigerian authorities captured Kanu in 2021, weeks he was in Kenya, and subjected him to inhuman and degrading treatment, and crucially that he was subject to rendition. However, despite clearing recognizing the gravity of the wrongs committed against Mr. Kanu, the court disappointedly held that Mr. Kanu has no legitimate expectation that the British government should reach a firm view for itself on what had occurred for its seriousness. This is particularly surprising, given that the court itself reached the view that Mr. Kanu had been renditioned on the basis of the evidence before it. The court judgment is unsatisfactory, not just for Mr. Kanu, but for any British national who found themselves subject to a serious violation of their rights weeks abroad. It effectively enables the Foreign Secretary to prevaricate indefinitely in the face of such a violation, and consequently limit the steps the British authorities should take to assist a British national, even in circumstances where there is evidence of that violation. The Kanu family has appealed against the judgment. Reflecting on the judgment, Kingsley Kanu, who brought the lawsuit, said, "The UK High Court has now joined the Nigerian High Court and Court of Appeal and the United Nations in recognizing correctly that my brother was subject to extraordinary rendition. That is something of importance. But I find it very disappointing that in spite of this, the High Court has held that the British authorities are not required to reach a decisive view on his rendition, and then refuse to confront the mass of evidence of what has occurred. Until the British authorities reach such a view, it is impossible for them to properly consider what steps should be taken to assist my brother. Kanu's family is represented by John Harford and Shireen Maka of Blind Man's LL, together with the Charlotte Kellogg QC of Blackstone's Chambers. Ms. Maka said today that despite taking 4 months to decide this case, the High Court has produced a judgment that's extremely difficult to reconcile with long-standing legal precedents and the principle underpinning it, which is that the British citizens abused abroad are entitled to expect decisiveness and protection from the British government rather than years of hand-wringing procrastination. When I dey tell una since say wetin happen to Mazi Nnamdi Kanu, say the hands of dis British government no comot for inside, e be like say na joke. They have been playing along all this while. That is the truth. They have been playing along. These are the real problem of Nigeria. They are the real enemies of this country.